Good morning, Gary. How are you?
I'm doing great.
Good. Welcome to Lawyer v. Lawyer. My name is Debbie Champion, and I'm here with Gary Berger today, and I've got a question.
Yep.
All right, Gary, during the coronavirus issue, I got in a handful or more of cases that I consider high exposure cases. And so they're those cases that keep you awake at night sometimes because you know the injury is catastrophic. And so I have a difficult time, or I have found myself having a difficult time evaluating those cases because some of them have really bad injuries, but the case isn't worth a hoot. You know what I mean? It's not as good, or it's questionable on liability. How do you evaluate those cases?
Well, I don't remember the not worth a hoot class from law school. Well, let me ask you that. Those that's a great question. So I think it's a great idea to focus on this episode on high exposure cases. On the one hand, they say from a plaintiff's lawyer, if you get liability, great liability, and then you have high damages, and then you have the three things, and then you have a high insurance limit, you hit the trifecta.
Yeah.
And as you go along in your legal career, you better relish those because those don't come every day. So what do you do if they're not good? So sometimes that's my worst nightmare, Debbie, is I have a high injury case.
Yeah.
But I got a car crash with no property damage. Or I got a slip and fall that I'm like, Lord. Or it's a tough med mal case where you go along and, you may have a breach of the standard of care, but you have real causation issues where they're going to defend this thing because your person was there for a reason. So there's that. Right. That's another way to expand on the don't give a hoot, not worth a hoot idea. So those keep me up at night, but I do two things with them. One is sometimes they're bad. Sometimes I'll tell you, because it's a defense lawyer's dream to have a high damages case I'll just say with shitty liability, and that means you are going to sit there. You're going to try it because unless many times. Unless you can get me to take $100,000 on $1 million case eventually or something like that, which sometimes I will. I'll recommend my client because my client's better off reducing the liens, putting something in their pocket and walking away from this deal. But I also say, I'm walking in, there are, maybe not you, but there are other defense firms that would sit there and build, and that comes in and they're like, well, we're going to make $150,000 a year in this case for 3 years in billables. And so we're going to work this shit out of this, the heck out of this case. So it's my worst nightmare. The other thing I do, though, is I also say I judo it. And I say, how do I make this into a good liability case? What do I need to do? What medical article do I need to find? How do I dig in the medical? How do I go find all the OSIs, the prior incidents when 20 other people slipped in the same place? How do I go take the great corporate designee deposition depot and get them to admit liability or agree to my rules? What can I do to judo the bad liability and to make it a great liability case? What do I need to focus group on it, et cetera, et cetera? And I know I gave you a long answer, but let me reverse it to you on the defense side, Debbie. What do you do when you have a high exposure case? Let's just keep on the same track. High exposure case, questionable liability, or not worth a hoot liability.
Well, I would much rather have a case that is, and I think you suggested maybe just the opposite. I would much rather have a case with 100% liability but questionable injury. I would much rather have that case. I can fight that case. I can teach a jury medical. I can teach a jury brain damage, or when there's not brain damage, but I can't teach a jury how not to feel bad for somebody if there's really a legitimate injury. And so that's what's tough. And so I'll tell you some suggestions that I've heard. I'm not necessarily great about doing it, but some suggestions that I've heard in these bad injury, not so bad liability cases is to start early trying to see where that's going to fall and what your juries are going to do. So the theory is start at the end of the case. Where are you going to be? Who are your jurors? what county are you in, and what are those what people in those county, what are those residents going to think about this particular plaintiff and the limitations caused by that injury. You know, I remember sitting through voir dire, just watching a case that I had a vague interest in because I think I was the work comp sub-row attorney or something. Watching this jury up in a case north of Hannibal, I don't remember what county it was. And the man had a horrific injury, and liability was questionable. But this injury was not questionable. It was a bad injury. And it happened as a result of the inhalation of something. I don't remember whether it was silicosis. I don't remember if it was mesothelioma. I don't remember what the injury was, but it was bad. And he was dying. And the jurors, one after the other, raised their hand and said, yeah, sometimes you just get bad things that happen to you. And I'm like, what? And then the guy didn't wear a mask all the time, or said he did, but of course the question was, do you believe he did, or something like that. And the jurors were like, yeah, you get hot, you take those things off. That's just a risk with the job. You got to work. It was the most conservative group of people I've ever seen in my life. If I had that jury, it'd be a lot different than I'm analyzing the value of that case potentially for people around where we are, because those people don't care about the injury. They take it. If you put an iron on your hand and burn your hand straight through, well, isn't that too bad? That's bad. You're not going to be able to work for a couple of days. I mean, it's just terrible. And so you got to know who your people are. You got to work the case backwards.
Know where your venue is and what the jury is going to like.
Exactly.
So before you get to your second one, so 2 years ago, I set the record for the best defense verdict in a case that I tried and lost. And the defense lawyer there, and I'll mention his name, Tad Eckenrode,
sure,
who's a great defense lawyer. He got up and he said, what happened to this family is terrible. You can't imagine anything worse than what happened. And he acknowledged the damages in a heartfelt, true way. And then he ended up defending it on liability, and he won.
Did you have a sympathetic jury?
That's a great question. I was in a conservative venue. I tried to voir dire about this. We talked about it. I struck so many for cause. But the first box to me, the left-hand side, their right-hand side, they weren't talking. I couldn't get them to talk, and I tried, and I thought there might be some quiet, sit on their hands people, and they the first box is where they draw a lot from, right? So and I couldn't, and they ended up being on my jury. It was a 9-3, and I tried, and I spent the whole time talking about liability and causation. I did, we talked about damages too, but that had already been proved. I tried to do my best, and
I'm guessing if Tad were here, he would tell us he anticipated that jury was not sympathetic, because psychologically, if you have somebody who is sympathetic, and I, as the defense lawyer, am overly sympathetic, or I'm also sympathetic, it pushes the sympathetic people toward the other side because they think I'm not going to be mad. But if I've got a jury I think is less sympathetic than I am, and I'm sympathetic, then they just pity me because I'm pitiful, because I'm so sympathetic for this plaintiff, and they push me farther
say that
away.
again. I'm trying to follow. So let me say that Tad thought there was going to be a plaintiff's verdict. He was surprised at the result.
Then he would not have been. Well, he may tell you he was surprised at the result.
That's true. If he was being nice to me, he knew he was going to whoop me the whole time.
But I think that from a psychological perspective, if I'm trying to convince a person of something about
a jury,
somebody else,
let's say, so tell me,
a group of people,
then
if they're already leaning towards you, and I am more sympathetic to you than normally I would be, it pushes them toward you. And the reason for that is they think, well, okay, I'm not going to alienate her by doing that. So good, I can go ahead and be over here on this side, and she forgives me. Whereas if it's the opposite way, where I have those people up in that northern county, or I have people who are less sympathetic to the plaintiff, and I've seen them give the plaintiff the stink eye when they're testifying, and I think I got them.
Yeah.
Then I'm going to be more sympathetic to the plaintiff in front of them, because that entrenches them away from that, and they feel sorry for me because the plaintiff's fooled me. And they get madder. It's interesting to watch.
So you're playing that dynamic during trial.
Absolutely.
A trial call, and maybe it changes during your cross
That's
event.
exactly
You're
right.
watching the jury, and they think that the jury. So that's it. We've done a lot of cross examination stuff too. So
Yeah.
like if you see the jury looking askance or stink eye at a plaintiff's answers, you're not gonna combat the plaintiff on the bullshit nature of the answers. You're gonna say, okay, well that's fine. So you did have 20 years of back problems, but this isn't related. Is that what you? Okay, that's fine. Okay, we'll accept that.
But it's worse than that. If I think they're not believing the plaintiff, then I will overtly say things like, "Are you uncomfortable? Do you need to take a break?" and in
Do you need
there,
a glass of water?
and in my closing, I will
And
say,
they're sitting there going, "Why are you being so nice to this
exactly.
liar?"
Then they like me because they don't believe the plaintiff. And yet when in the closing I say, I really feel bad for the plaintiff here. She clearly
You're
has
so
a problem.
full of
I
shit.
just don't think the problem. Blah blah blah. The jury is even it entrenches them in their opinion against the plaintiff if they already lean that way. Now the question is, which am I guessing it wrong?
How'd you learn that? How'd
See,
you learn
I got
to do
that psych background. Remember?
That's brilliant.
Yeah,
That's
so-
really smart.
And so I try to read all that stuff that I can put my hands on.
So let's go back to, let's connect this, and maybe we already did, to the high exposure case. In a high exposure case, tell me what you're doing with that lesson. What are you doing?
So with the high exposure case, what we're talking about are people who make a lot of money or people who are really injured. That's what we're talking about. And so as a subset of that high exposure case where there's no liability, I'm talking about the people who are really, really hurt. That you've got to read what your juror thinks about that plaintiff. And if you get lucky or unlucky enough to get a jury group who you think the majority is not buying something the plaintiff is selling, like a brain damage case,
Right.
then you don't fight the plaintiff. You don't give the jury a reason to take up with the plaintiff against your aggression.
Right. You don't challenge them on those
Right.
damages. You hammer home liability
That's
and
right.
say, just like the case I was
That's
giving
right.
an example. Sometimes when I'm in trial, I don't read people that well. Or I found myself, I've read them the wrong way. The other thing, though, is I'm so busy trying my case.
That's what I was going to say. You can't read them.
Is that
can't
I'm
read them
trying to
or
get
read
this document and this, and I'm trying to do my questions, and I'd worked on my plaintiff, I'm trying to cross this, is that I don't have, so you know what I've
hard to
done?
read a jury.
You know what I've done? I've had some trials where I have someone else in the courtroom who's watching the jury because I can't, and I've had this in a couple trials where I had a young law student helping me in a trial, and she's like, they love your case. They hate the other side. Every time the other lawyer gets up, they're these two women in the corner were looking at each other like we hate her. They're crossing their arms or something.
We do that too. I use summer law clerks because summer law clerks don't impose their legal thoughts on it yet. They're just looking like at the jury as an observer, and they just take
Before they
notes.
get tainted with the law.
Exactly right. Or before they get into the case so much that they're rooting for the case. They're just trying to be objective, and they will write everything down. I love that. I did that a couple years ago, maybe last year, in a case, and it was invaluable if you could have somebody else in there.
So what do you do would you do anything with early resolution in a high exposure case?
Yes, I was going to talk to you about that too. You know what you need to do, what defense lawyers need to do in those cases, those high exposure cases because of the injury, is you do jury research. I can't tell you I would say probably 95% of the cases that I do jury research for, I do it when I'm doing my pretrial, which is 60 days before trial. So what the heck am I waiting for? You know what I mean? Well, they don't like to spend the money on that kind of stuff until the last minute. But in a high exposure case, you need to get it early so you have an idea of what it is. I mean, if let's say you've got somebody with a burn. What's that worth? Well, I don't know. I'm going to make it up. I don't know. I'm going to kind of give some educated guess. But the real truth is, let's look at the history. So I don't think that's what you asked me, though, was it?
No.
Okay.
Yeah.
Okay.
Well,
So
no.
that's the real. Oh, and I know what I was going to bring it back to you.
Early resolution.
Early resolution. The other thing is focus groups. You hit the nail on the head on that.
You do focus groups?
No, but you said it earlier.
Yeah, I do.
And I do focus groups, but I often do exactly the same thing. I'm doing my focus group right before we go to
I
trial.
do it too. I don't do it at the beginning. I do it at the end because I don't want to spend the money.
If you've got a case somebody can't evaluate.
Let
Do
me
it
ask you
early.
this: Do you ever worry that if it's a high exposure, bad damages, bad liability,
Yeah.
tough liability for the plaintiff? Do you worry that you want to settle it early because if they get in there, that plaintiff may find some stuff. They may find some OSIs, other similar incidents. They may find a memo from my damn client or they may take some depots, and some of these corporate reps Berger may be able to get them to fold over and do some BS. So maybe they'll take a discount early because the plaintiff thinks that it's crappy liability. Or no.
I like to try to settle those early, but not for those reasons.
Tell me why that.
Because when I'm evaluating the case, I'm assuming all that crap's coming out.
Oh.
So I'm evaluating it generally as high as I'm going to evaluate it. And now that other people don't do that. You know, what I see in other lawyers' cases, that they evaluate low and then they get bigger and then they get bigger. I don't like to change my evaluation. Sometimes you have to. But if it's a bad case, I'm going to evaluate the damages separate from liability. And I'm going to tell you what I think that injury is worth. And so why not try to settle it early then? Because if you can get it settled early, and I told you a little, I think earlier before we started maybe this podcast, or maybe it was the last one, where I told you I had a case that came in and the demand was under my evaluation. And the client wanted to fight about it. It was way under my evaluation. And I'm like, fight about it. Do what you need to do. Anyway, the case ended up getting settled. But it was kind of a little kooky because clearly what we had is somebody who didn't, either I didn't know the valuation value, or he didn't know the evaluation value, or he knew something I didn't know. It was going to cost the client money to get there so I could figure it out.
Did the lawyer know what he was doing, or was it a new lawyer?
No, it was not somebody who totally was off base. They knew how to try cases. They knew what they were doing, and they wanted to get the case settled. And, my personal belief was it was a situation where a low offer was going to come in. They knew the people were not going to pay it, and then it was going to skyrocket. And it was going to go above what the real value was. And then we were going to have to start over and fight it and spend a lot of money. And so we mediated that case, and it settled for a good number. And I think kind of everybody walked away happy. But even in that scenario, my client walked away suspicious about why it went for so low. Well, it went for so low because the client wanted to settle the case.
Huh. So, I've had some I've recently had I've been settling a lot of cases, but I've been looking back at some demands I sent a year and a half ago or something, and my demands are so high. Some of my associates or other people, or maybe I was thinking wrong, and I'm putting these huge numbers on these cases that I then look at and go, what was I thinking? So, because I try to be, I'm going to put plenty of padding in my demand so I can come down. But I also don't like to do a demand that is 2 or 3 times what I'm going to take in the case, because I don't think I have a lot of credibility. But then again, I think, maybe they'll offer it, but then I never have a case where I do a high demand and they say, okay, and I'm like, oh my God, their first offer is huge, because they want to test me. So I know this isn't necessarily, but on high exposure, because high exposure, you're going to send out a big number.
Yeah.
So what do you think about what do plaintiffs' lawyers do, good and bad, in terms of setting initial numbers on demands and stuff? What do you think about starting too high?
It is all over the board.
Really?
So unless I know what client you're talking about, I can't give you the answer. It changes for every person I deal with.
I mean, every plaintiff's lawyer, or
every
your clients?
Of my clients. And so I will say, let's say you've got a case and somebody writes me a demand or whatever, and it's way too high. I will sometimes call and say, this client's not going to ignore this. But that's not often. But this particular client might ignore it because it's so outrageous they might just ignore it. But that's not very often. So from my perspective, when I get a demand, I don't care what the demand is. If it's a $30,000 case, do you demand $3 million? I don't care. It's not personal to me. You don't know what the case is worth. You don't care. Whatever. We're going to get there eventually. But I don't care what the demand is. But my clients do. And so a $3 million demand, some of them will just laugh at that and respond with the appropriate offer. End of story. Some of them will just ignore it because it's too high. I don't understand that thought, but that's what some people do. So it really is all over the board what they will do with that. Sometimes
I have a number of cases where my demands were so high, and I'm sitting there going, listen, call the other lawyer, get them to make you an offer, because we need to come off this thing by a couple $100,000 and get in the right ballpark.
Well, and I think that helps. If some lawyer will call me and say, no, this is outrageous, I didn't know where to start on this. Okay, got it. We can take care of it. So then I could tell the crazy
Right.
client who says, I'm not responding to this at all. I can say,
What
I
should
know
plaintiffs' lawyers do? What should plaintiffs' lawyers do to get a good settlement or a good resolution in terms of starting with their demand and thereafter?
I don't care. All I care is this. Here's what
I'm trying to get something from you, Debbie.
Here's what I care about.
For me.
The best way to get my top dollar on a case,
Yeah.
make sure we're communicating. Because if I know kind of where I think you're going to go and I can get the client there, it's no skin off my back. I don't care. I want the client to be happy, and if everybody else is happy too, that's great. I don't care. I don't need to try that case. But people are always thinking you're pulling something on them. And sometimes I am if I'm not communicating with the person. Sometimes maybe that's true. But most of the time, I'm just trying to get to a number that my client is happy with that you'll take too.
I can't tell you how often that happens on my side because I'm like, did you call the defense lawyer? No. So you're just sending emails and you're calling. I mean, you got to pick up the phone and then I'll have and then I'll pick up the phone and I'll call and the defense lawyer and I'll get to the number pretty darn quick.
And it's changed because I used to know what that number was, what my client would take. I used to know. I don't know any time in now. They all do that, but I kind of can. I know what I've told them to pay, and most of the time it's going to be around that area.
All right, so high exposure cases. Let's keep on our topic here. No, I'm doing this for me, not because I'm saying you were straying at all. Let me ask you this, though. So high exposure, how do I get the mammoth settlement so I can put it on a plaque on my wall and be in the Lawyers Weekly and talk about how great I am?
You have a way better answer to that question than I do.
No, I mean, so how does the the common wisdom is work it up till trial, and the closer you get to trial, the more money you're going to get. True or not true?
Again, it depends on the client. My general belief, if a client comes to you early and offers to mediate, is that's probably not going to happen. I mean, I've had...
Wait. Tell me that again.
If a client wants to get rid of it early and they've put a good number in what they believe their best number is early on, you may get it up a little bit, but it's not going to go up much.
So what you're saying is if the client has well evaluated, you evaluate it, they call you and they call the plaintiffs and they say, listen, we want to pay you on this thing. We know we're good for it, and we're going to put all our money on the table. That the plaintiff's lawyer should take that as true, and that working the case up for 2 years, you're not going to get a lot more from
That's right. And now they've spent the money on the experts and this and that and the other. They're not inclined to want to settle that. Now they're willing to run the risk. That is unless
because they've already budgeted for that.
That's
They've already put their reserves for
That's
that.
right.
And so if you go tag them for $1 million, they don't care because they already said it was $1 million 2 years before.
And now that you're saying that, remember too, a lot of those kind of coverages are depleted.
It's an eroding policy.
That's exactly right. So they're paying me, and their policy limit's going down.
Tell our listeners what that means. We've done a podcast on this a long time ago, but tell them what it is again.
So a lot of those big policies with corporate policies are eroding policies where the insurance payment, could be under an indemnity claim or it could be under an additional insured claim, but the payment for that particular defendant and their counsel is eroding the policy limit. So it starts out at, let's say, $1 million, and you've paid now $200,000 to the attorney to defend the case all the way to trial, and now you've got $800,000 you can get. And that company may not be doing well. It may be going out of business, and you may just have given away $200,000 you could have gotten earlier.
I've had a two on that. I've had a number of times where I've talked to other lawyers and it's a big case and I tell you that, and then I ask an eroding policy and they go, "Oh, I don't know. Let me go look."
That's right. We never know that.
Well, no, but it's a good question. And then this number two is I also had a smart lawyer call me, case I settled last year, where they said, "Listen, this is an eroding policy too. You can go work the heck out of it, Gary, but here's the deal. If it's worth $1 million now, it's going to be worth $800,000 in a year and a half because we're going to put in that much money in the case. So you might as well take it now."
Yeah.
What about, okay, so now, however, what if it's a case where, but so if to follow the train of thought, if the defense isn't, I also have cases where I give a big demand and I don't hear, it's crickets on the other side, and I say to myself, well, they don't believe me. So now I'm going to have to go work it, and I'm going to have to persuade them of the wisdom of my position. I'm going to go whoop them, beat them around here and there until I get them up to where I think they should be.
That's the way to do it.
All right.
Yeah, you have to do that.
Because you may have a client who's just, they may say to you, what if they're not offering the money right away? Should the plaintiff lawyer work it up to trial?
It depends on what you mean by right away. Sometimes sometimes you just need to call the attorney and say, why have I gotten a response? I'm going to start working this case if I've waited long enough, and that'll get it moving. Because sometimes it's just, is this just a demand from a file, or do I really need a response to this? Believe it or not, some companies don't respond unless they think they really need to respond.
Okay.
It's weird.
Right.
But I don't think the lack of a response should be an indication to you that they don't think the case is worth anything. I think it's just either they don't think they know enough yet to respond to it, or they think it's going to be more appropriate to respond when we know A, B, and C. But you could tell them A, B, C, and D, and then they might come up with a response. So I think, again, I'm the world's worst about calling people, but I think that's the key.
One of the things that I've done before, and tell me if this is effective, is I'll call the other lawyer and I'll say, listen, is this a deal where you're calling the shots, your client's calling the shots? Is it worth it? Because if you're not, is this something where your adjusters, make it every little nuance? Because the reason why I'm thinking this is you keep saying it depends on the client.
Yeah.
So what I sometimes do is call the other lawyer and say, now I know you don't want to, I'm not asking for attorney-client stuff.
Yeah.
But is this something where the lawyer's calling the shots or not? And I'll have lawyers telling me, say, yeah, I am, and this is what I think of the case, Gary, and da-da-da. I go, okay, cool. Sometimes they'll say, listen, I'm telling everything to the client, but they're not listening to me. I have one case right now where I joke with the other lawyer. I said, the case, but the only person who's listening to you is me. Your client isn't.
Right. It's the only lawyers that call. I mean, let me just say this. 20 years ago, the lawyers could kind of tell you what you could expect in a case. Now, absolutely silence. It's silence on the other side. I don't often know what they're thinking. I don't know what their top number is. I was negotiating this case recently. It was really frustrating because the guy kept saying, is that the top number? I'm like, I don't know. I don't know if it's the top number. Well, have they said that? Well, I can tell you they've said, well, I'm going to offer about one or two more offers, but I don't know the top number. They don't give me the authority anymore to try to negotiate a case in. It's drips and drabs.
What else should we talk about high exposure cases?
The only other thing I would say to think about is whether or not the facts are heinous or sensational, and that those facts are things the defendant might not want to get out because you can settle those earlier in many cases.
With a confidentiality.
Yeah, because it could be that the reason the things the jury will hear will still understand there's no liability, but what happened to the plaintiff was so bad that you're going to pay for it anyway. I mean, I can't tell you the number of millions of dollars I have paid out in cases where there's no liability. But what happened to the plaintiff was so bad that the insurance company understood that a jury was going to be shocked by it. And it may not have anything to do with what the defendant did.
Give me an example of what you mean. Like the injuries were so bad, like a death or a broken or a paralysis or
a leg off or paralysis, or maybe a situation where somebody appeared to be trying to commit suicide, but there was something that went wrong either in the way the vehicle was operating when they ran it into a tree, or the way the drug combination that the plaintiff put together that they weren't warned against, and nobody in the nation would say that was a warning you could have anticipated. That sort of thing. Yeah, you used my product to do A, B, or C in a totally improper manner that wouldn't have been anticipated, and you did it, the misuse of a product. So you lost your arm or you lost your leg. Had nothing to do with the product, had to do with you, but yet you've been through. Or security claims. Security claims are the worst. People either get shot, they get killed, they get raped, they get, bad things happen.
Bad things happen.
Yeah, and it has nothing to do with any prior history of crime in the area. There's no, and maybe you had security there, but they got around security, or they killed security, got past security in some way. Because security doesn't mean I'm going to prevent this from happening. It just means I'm going to try to make the area more secure. But if you kill the security guard, then, what do you do?
Have you had a case like that?
Yeah, I've had cases like that. Those are not fun cases. But it's
Let
so
me-
bad people feel sorry for the families. Or
Yeah,
the
because you want to be
person.
safe in your
Yeah.
home or safe in
And
that
you,
business.
and you understand, and you'll talk to the jurors later, and they're like, yeah, the defendants did nothing wrong.
I don't know. All right, let me ask you this. And we're almost out of time, but because you prompted a question for me, because you started to talk about different types of cases, is there anything about the kind of case it is liability-wise that changes the analysis in high-exposure cases? For instance, if it's an employment case. For instance, if it's a product case versus a car crash versus a truck crash versus a premises versus a security case. Anything about the nature of the liability in the cases that changes the high-exposure analysis that we've discussed?
It depends on the jury. If it's a discrimination case, based on anything like religion or race, and sometimes even gender, and you're in front of a liberal jury, then that's going to change the analysis.
Yeah.
But if it's an employment case where we're talking more about money for a high-paid executive who had a gender discrimination or even a race discrimination, then it doesn't really matter as much about the height. Right. In other words, when you say, "Oh, you didn't pay me as much," that you analyze that just like you do any other case. But when you say, "You treated me badly because of my race or my religion," that's a different issue than "you didn't pay me as much." You follow me?
Yeah.
So when it's a personal attack on a
Not
person,
paying me enough it's not going to resonate with the jury as much, especially in a high.
And not even necessarily that. You just evaluate it like you normally would any case. It's a damages case. You evaluate it. You evaluate the liability, and then you got your numbers. And they may be big numbers, and the jury may not care about those numbers, and they may not award that number. But you can kind of analyze, generally how much a jury is going to give somebody, how many months or how many years a jury is going to give somebody based upon what the facts are in the case. But when it is bad acts resulting from what somebody did to you because of a characteristic you have, that's a different show.
What about trucking or products cases?
Trucking cases always start off bad. Products cases do not. People aren't automatically mad about a product.
Isn't products litigation changed in the last 20 years? It seems like the cases are tougher now. I don't see them as much.
Yeah, you don't see them. They're expensive. They're expensive to work out.
I've lost a couple.
They're expensive to. Well, think about that though. Think about all the changes in the last 30 years or 40 years in manufacturing guidelines, and so you don't see as many badly manufactured items. You do sometimes. I had a plaintiff's case a year ago with a deer stand, and the instructions were like a cartoon. It was ridiculous, and so and the manufacturing was the defect because we had steel that was improper. So sometimes you can see a product's case that's good. They're not as frequent anymore because people have safer products.
All right, thanks for talking to us about a great question to start this one out about high exposure cases, Debbie. Thanks.
Thank you, Gary.
All right, that's all we have for this episode
Talk
of
to y'all
Lawyer
soon.
versus Lawyer.